call on this. Looking at contract. So the four elements that are really important supporting a contract. The first of those is it has to be an environment where there is a genuine intention to create legal relations. It's not just a flippant comment made between two people. Then there has to be an offer. And here we want to be sure we can differentiate an offer from an invitation to treat, which is just an ad. Is it formal enough to be an offer, or is it just an advertisement? We're going to look at these all in a bit more detail. Acceptance. Is the acceptance clearly communicated and unqualified and communicated within proper timeframes? Then it will be acceptance and consideration. Has something of value been exchanged for the contract? So let's have a look at these individually. First of all, what is an offer? So the offer is the proposal by one party to enter into a legally binding agreement. You can make that offer in different ways. For example, it can be made orally. You can communicate an offer that way. It can be in writing. And in rarer cases, it can be in conduct. And we have had a look at the case where there was someone who bought one of the smoking machines in the 1800s under a promise to cure the flu or stop them from getting the flu. And their act of using it was part of the forming of a contract. Yeah?
You know you said that if it's an oral agreement.
Yep.
What if you were deaf and you signed it?
Sorry, what if you
were deaf and you signed it? Would that still be okay?
I don't actually know the subtlety of sign language, but it may be that sign language fits into this idea of by conduct.
Oh.
Right, so if it fits in all the other elements, I think maybe that could fit in, yeah.
What if it's also made in another, like if it's agreed to in another language?
Okay, there are rules.
Because then if you get a translator, the translator could like be paid to say something.
Yes, there are other rules that we will look at later that look at the validity of a contract. Okay, and some of the things that might make a contract less valid are if there's a power imbalance between two people or if there's been some fraudulent activity, which is what you're alluding to there. So they are things that could see a contract set aside. Okay, now, the important thing is you have to distinguish it from an invitation to treat, which is an advertisement. Here are the important elements of an offer, right? Here are the general principles of an offer. Right? An offer can be made to either a particular person or a whole group of people, all the students at a school, or it can be made to the whole world. That carbolic smoke ball company case that we looked at, it was made to anyone who purchased a carbolic smoke ball machine, whatever that might be. Right. Offer must be communicated to the person who's accepting the offer. Right. That's fairly clear. All the terms of the offer must be communicated to the person accepting the offer and brought to their notice. You can't have a complete offer if you then add terms later on. So if someone makes an offer and later on adds some extra terms, those terms haven't been communicated. That's a real problem. The offer might have conditions that have to be followed. It can be withdrawn at any time before acceptance. So you can let a party know that you've made an offer to that their offer is no longer available provided they haven't accepted it. And if there's not a time frame with the offer, you get to this slightly vaguer idea that if it's not accepted within a reasonable time frame, then the offer lapses. So they're the general principles for offer. Has anyone got any of those that they're not sure about, they're unclear about, they want some clarity? So if you know those and they're becoming more familiar, you're in good shape. Okay. After the process of making an offer, the person has to accept. Now, one of the things that's got to be careful is to understand the difference between acceptance and a counteroffer, and that's what we've got to make sure we're able to differentiate for. Okay, so where this occurs when one person agrees to the proposal the other person is making, and that's why if you try and change that proposal, for example, if I'm trying to buy a boat off someone, they've offered to sell me the boat for $15,000. I say to them, I'll buy the boat for $15,000 provided you throw in 3 fishing rods. That no longer becomes acceptance because I've put an extra condition in there. I haven't agreed to the proposal the other person is making. I've tried to change it and get some fishing rods thrown in that case. So here are the principles. Acceptance has to be actually communicated. You have to let someone know that you have accepted their offer. A qualified acceptance cannot be made. Any offer must be wholly accepted or it becomes a counteroffer. that then the person who's selling the boat might say, yes, I agree that I'm going to sell you the boat for this amount of money with you paying in this period of time, with the fishing rods included into it. Any conditions stated have to be followed. Acceptance can only be made by the party to whom the offer was made. If I make an offer to someone to sell my house for $435,000 payable in 30 days' time, subject to whatever conditions, that doesn't mean that other people can expect to get that offer. Right? It's only to the person who the offer was made with. Once the acceptance has been communicated, you can't withdraw the offer. That was consistent with what we saw on the last slide. It can only be withdrawn up to the point in time in which it has been accepted. Has to be made within the reasonable time frame, once again, and the person accepting the offer must know that it exists. Okay, so you can't be tricked into accepting an offer without really understanding it, without understanding it exists. The last thing in these first three areas is consideration, the one we've touched on most recently. So for agreement to be binding, some gain or benefit must pass to the person making the promise. If I'm going to buy, for example, a fancy stove at the, is it Miele? Is that how you pronounce the fancy? Miele, sorry. Yeah, okay, yeah. If I'm going to buy the Miele stove, the reason I leave a deposit is that so that there is some benefit that's passed to the seller of the stove, that they will come and give it to me. This gain, this benefit is consideration. Probably the most common example is a deposit. So, consideration must exist in every simple contract. As long as there is consideration, the court is not concerned as to its adequacy, provided it is of some value, provided it has some value. It doesn't have to be $1,000 for a $10,000 car. It just has to have some value. It can't be illegal or unlawful, right? I can't form a legal contract by asking someone to give me a couple of joints of marijuana. I can't get that to happen through something that's illegal or unlawful. It has to be definite. It can't be something that relates to past performance. Well, that is not good quality. Yeah.
We never touched on this, but can you enter into an agreement with someone under 18 if you're under 18?
We'll look at there are very specific rules around someone who is under the age of being an adult. It means they can do, for example, they can contract for necessities. So you might find that you're able to enter into mobile phone contracts, even under the age of 18. But there are other contracts that you will find that you won't be able to, or you need extra advice. And there are rules that happen about things when you turn 18. You should have to restate the contract, re-agree with the contract when you get to an adult. So there are specific rules around what a junior can do, and they are something we will specifically look at later on. Nice question.
If you're, say, like, I'm making an agreement with, like, an agreement for a fee, because we're both under 18, is it not binding?
You would, if it was a true contract, right? If you truly wanted to set in a situation where you could, there are rules. I think it would depend a lot on whether it was seen as a necessity or not, and there would be a lower sort of ability to prosecute it if you wanted to argue about it. So there are limitations, yes.
Would it be any different if we were, like, really wealthy? Like, if I was trying to sell her a house?
Well, if you're trying to do that, you would have, the key difference is you would be getting high quality legal advice on that. Right? But there are restrictions even on the ownership and taxation of assets of people underage. So I'm not entirely sure what situations you'd find yourself in.
Can you, on top of what Lara said,
Yep.
can't me and Lara technically, can't Lara and I technically enter into an agreement if our parents say we can?
Okay, that is one thing that's one thing that often happens, is that there will be someone who would act as like a guardian type role. It often happens in civil court cases as well. So that may be the way an agreement could be formed. But we'll have a look at the role of age in contracts a little bit later on.
Yeah, but like can't 16-year-olds get married with parents' consent?
Yes, but remember I don't know exactly the laws around that, but remember there is a separate role there for parental consent. Right? Okay, a few other things about consideration. Right, and just go through these. Make sure that you guys are comfortable with all of them. You must be something that's possible to.
Wait, can 16-year-olds get married?
Yeah, it's like your parents are saying.
Okay, let's keep on with this for the moment, thanks. It must be something that is possible to carry out. It must be something that's provided by the person who has made the promise. So we're looking at something between the two parties in the contract. If someone promises to do something which they're already obliged to do under contract, then it's not consideration. If you already have an agreement, if Lara and I already have an agreement that every day I go and do some work at her place, that work can't be used as a consideration in the contract. Okay, it has to be beyond something else. You could consider using a promise not to take legal action against someone in the future, and agreeing to settle a legal claim. So those things, they'd be quite unusual, but you can use a legal claim as a situation of consideration. Are there any other questions about consideration then?
Can you just can consideration just be like a promise?
Okay, can consideration just be a promise? Who thinks yes? Hands up if you think consideration can be a promise. Who thinks no? Why no? John, why no?
Because doesn't it have to be like in a legal sort of setting, like legally binding? And depending on like what the promise is.
No, can't you just be like, I promise I'll do it?
But do what though? Like,
Yeah, you're on the idea. What is the core definition of consideration that I think a promise is not adequate? What's the core definition of consideration?
I have to gain benefit.
Yes. Okay, it has to be something of value, a gain or a benefit. Right? And maybe you might say a promise is a nice thing and get all romantic and stuff like that, but I don't think that is what they're looking for. What they're looking for is something like a deposit or some of the goods to pass or something like that. Right? They're the things we're looking at.
Okay, this is weird. Isn't marriage technically a contract? Because they call them marriage contracts, right? So what do you give them as consideration? I love engagement ring. Don't worry about it. I'm on it.
You're on it. Nice work.
I'm on already.